One of the dilemmas that real estate brokers face every week of their practice is to, on the one hand, convey the value proposition to your clients and your prospective clients that it is worthwhile for them to engage your services, while, on the other hand, avoiding the unauthorized practice of law. Let me give you some examples of what I'm talking about. In the residential arena, a real common example is some buyers expect their broker to evaluate whether the property can be used for temporary rentals, such as Airbnb or VRBO. Another example is a buyer wants the real estate broker to evaluate whether the buyer can bring horses onto the property, keep horses on the property. In the commercial arena, there's all sorts of examples. A buyer might want their broker to evaluate whether the property can be converted from its current use as this big old mansion kind of house into perhaps an office building. A broker is asked to evaluate whether a warehouse can be used for a marijuana grow operation. A broker is asked whether the first floor of a building that's currently used as office can be converted to a hair salon. Those are all examples of recent cases that my law firm has defended where the broker did a pretty darn good job of evaluating all those things, but pretty good doesn't work. It has to be perfect. Every check of the checklist has to be perfect for your client to be able to use the property that they close on the way the buyer wants to use it. And if it's not, and they've relied on you doing the due diligence, they're going to be miffed at you, that could create lawsuit problems and regulatory problems for you. So, how do you deal with that dilemma? Here's my suggestion. You let your clients know that you will do some due diligence on the property. You will go talk to the planner. You will try and gather a copy of the zoning map and the PUD and other things that are necessary for these kinds of evaluations. You will gather up the well permits, etc. But that any due diligence that you do, while it may be sufficient for the buyer to rely on for the pursuit of the property, perhaps it's even reliable enough for the buyer to enter into a contract to buy the property, that it is not reliable enough. The due diligence that you do as a broker is not sufficiently reliable enough for the buyer to rely on your evaluation to close. The contract needs to have a contingency, making the buyer's obligation to close being contingent upon the buyer's satisfaction with the buyer's future use or future development of the property. And those kinds of contingencies are naturally built into the pre-printed language in the Real Estate Commission approved form. It's not good enough to explain and to depress your client's expectations about the quality of your due diligence verbally. You've got to put it in writing. And the natural place to do that is to put it into the exclusive right to buy agreement that your buyer signs. And of course, in the law firm, the Frascona, Joyner, Goodman, and Greenstein 2020 Standard Clause Library, we have added a clause that does exactly that. It is a clause that you put in the exclusive right to buy agreement that says any due diligence that the broker conducts might be reliable enough for the buyer to pursue the property, but is not reliable enough for the buyer to rely on to close on the acquisition of the property. The buyer is advised by you, the broker, to consult lawyers, land planners, and other experts before the buyer loses the opportunity to bail on the contract. Ladies and gentlemen, it is a complex world. Be careful out there.